Hey everybody, Stuart Green, founding and managing attorney of Stuart Green Law. And today I'm going to talk about the best way to receive an inheritance, or said another way, the best way to pass an inheritance to someone else. And this is rarely a question that people think about when they're thinking through their estate plan. And I'm going to explain why this is important throughout this, but just ask yourself, what is the best way to pass an inheritance to someone else? And it's done through an inheritor's trust. There's a few different acronyms for inheritor's trust that you might hear. BEAT IT is probably the most common one, a beneficiary defective inheritor's trust. And what that ultimately means is that any taxable activity inside that trust just ends up going on the beneficiary's 1040, their tax return that they complete each year. So it's not a separate taxable entity during that beneficiary's lifetime. Now, that could change, and that's a conversation further down the road, and that isn't the point of today's video. Point is, why is it most beneficial to pass an inheritance to someone through an inheritor's trust? And the answer is ultimately is because it's protected. And so what do I mean by that? So typically when someone receives an inheritance, they just receive it outright from a will, right? So Joe Smith says that he wants his estate shared equally among his 4 kids. They all receive a quarter of any assets that he had after, creditors are paid, that kind of thing. So that's great. Well, really, it's not great, but it works, I guess, is my point. But here's the fatal flaw with going that route. Those assets, when they're just passed through a will, are not protected. And by protected, I mean they are subject to any type of lawsuit, creditor claim, bankruptcy, a spousal claim, a divorcing spousal claim, and I'll talk about spousal claims a little more here in a second. And then also potentially estate inheritance tax. And while estate inheritance tax may not be an issue for you, it could be for future generations, right? You're leaving that to your children, most likely. It's going to continue to grow and appreciate over time. So if you can take care of estate inheritance tax now and completely eliminate it, why not do it for future generations? So that's just one of the aspects of an inheritor's trust that most people are missing out on, but really should be taken advantage of. So I want to jump back to spousal claims, right? So I recently got the question, let's say prospective client wasn't so much worried about leaving an inheritance to the child and the child getting divorced, but what if the child, say their spouse passed away, or better yet, let's say the child passes away and that spouse, that in-law, son-in-law, daughter-in-law, gets remarried to someone else that the parents don't know, right? Maybe that person already has kids from another marriage or whatever it may be. Now all of a sudden they pass an inheritance to their daughter. Daughter passes away. Now all of a sudden that son-in-law gets remarried to someone they don't know. Maybe they do know them, and maybe they just don't like them. Maybe they think they make bad life decisions. Maybe they have kids from a previous situation. Now any of that inheritance is going to that new family and funding vacations and education and sports teams and whatever it may be. Most people don't want to take that chance and they don't want to take that risk. So even if you aren't scared of the potential of a divorce for one of your children, which is protected with an inheritor's trust, there are other situations, worst case scenarios, that can protect any assets, any inheritance that you pass to your loved ones, to your children, to your grandchildren, any future generation, right? So point is, anytime that someone sets up a trust for the benefit of someone else, those assets, as long as they remain inside of the trust, are going to be protected from those things we talked about: lawsuits, creditors, spousal claims, estate and inheritance tax. Another fatal flaw that a lot of people make is they may set up a trust for the benefit of their children, pass the inheritance into the trust, but then for whatever reason, they decide to make staggered distributions. So what I mean by that, typically it looks like, hey, when my child reaches 25, they can receive a third of the inheritance inside the trust, and then another third when they hit 30, and the remaining third when they hit 35, or something like that. The point is, as soon as those assets come outside of that trust, they're no longer protected. Now, that may not bother some people, but if you can have the same type of control over assets inside of a trust that are it's protected, then why would you pass it outside of the trust to be open to all those types of different claims? So the point is that if you put the assets inside the trust, the beneficiary, who's typically your child, can control that trust and control those assets. And there's a few different ways to structure that. But what you really want to think about is that the inheritor's trust is really a beneficiary controlled trust. It's really a trust that's controlled by whoever you make the beneficiary, most likely your child, grandchild, someone else, right? So how do you structure that? There's really two different ways to do that. One is provides creditor protection. Another way provides more creditor protection. So the first way is that, let's say you set up an inheritor's trust for the benefit of your daughter. You could make your daughter also the trustee on the inheritor's trust. Now, you got to be careful with the way that you structure any distributions that they are able as trustee to make to themselves as beneficiary. So typically, to provide any type of creditor protection, spousal claim protection, estate inheritance tax exclusion and protection, is that you need to make sure that those distributions are to what's called or measured by an ascertainable standard. And so that's an IRS phrase. So HEMS, health, education, maintenance, and support. So as long as those distributions are for HEMS, health, education, maintenance, and support, the assets inside the trust are protected. Now, it is possible that a creditor could make a claim at any of those distributions for HEMS, but you don't necessarily have to make any distributions from the trust. So your child, the beneficiary, who's also the trustee, could say, you know what, there's this claim against me for whatever reason. I'm not going to make any distributions to myself. Therefore, a creditor is not going to be able to have a claim to any of those distributions. So what is HEMS? What is HEMS as it's called? Health, any type of health related expense, whether it's a doctor's bill, a dentist invoice, insurance costs, those kind of things. Education, pretty straightforward, paying for education. Maintenance and support, it's pretty generic. There are certainly things that qualify as maintenance and support expenses, but just think about your living expenses, right? Think about a mortgage, rent, maintenance and repairs costs to your house, those kind of things. So there's still a lot of flexibility there on how you can use those assets, use those distributions, and still have pretty strong creditor protection. Now, the most creditor-proof way to really structure a inheritor's trust, a beneficiary-controlled trust, is to have co-trustees, right? So you may have a third party who is maybe a friend, a family member, someone like that, or it could be a corporate trustee, maybe a trust department of a bank, or maybe just the trust company itself, who's kind of serving in that generic trust role. Then you could also make your child as who's the beneficiary. You can make them an investment trustee, meaning that they're really managing the investment and really managing the assets and how they're invested and everything that goes on with making sure those assets appreciate. They oversee all of that. They make all the decisions about that. Then you could also use a distribution trustee. And so really your child who's benefiting, the only decision that they're not making is regarding distributions. okay? When and how distributions are being made. So what's different from this option rather than the HEMS, the HEMS option, is that with this second option, you make all distributions purely discretionary. They can be made for anything. There's literally no constraints whatsoever on these types of distributions. So as such, a creditor can't make any claim to these distributions. They can, but it's ultimately not going to go anywhere, right? So that's the two things to really think about when you're thinking about how to pass an inheritance to your children or to someone else. The other thing to think about with an inheritor's beneficiary controlled trust is that it's irrevocable. And the fact that it is irrevocable is what provides that creditor protection. The fact that it is, a third party setting it up for the benefit of someone else and it's irrevocable is what really provides for that creditor protection. Now, usually when people hear the words irrevocable trust, they're like, hey, that's not for me. There's no flexibility there. I can't really accomplish what I want to accomplish. What if the absolute worst happens and we don't like the trust anymore? Maybe, my child develops a substance abuse problem. Maybe they marry someone that I don't like and they're sharing the inheritance with the spouse. Just whatever it could be. Maybe there's a change in tax laws. Point is that irrevocable trust is irrevocable. However, that does not mean that you can't amend or change provisions, alter provisions within the trust. The key is to have what's called a trust protector. And you give that trust protector all the powers they need to be able to work in conjunction with the beneficiary or the trustee, or work aside from them if the situation calls for that, to be able to make the decision about whether or not you need to amend, alter, kick assets out, whatever it may be. Set up a new trust with the assets inside of that original trust. So there's a lot of flexibility. It's just a matter of planning correctly and doing your due diligence and thinking through what's the best way to pass an inheritance to one of my beneficiaries. So one more thing to keep in mind, this is not legal advice. This is just general legal knowledge to share with you to help you think through the best way to structure your estate plan. Always consult an attorney, a legal professional, with any questions that you have or when you are setting up your estate plan. I'm more than happy to talk to you about it and talk through it. So if you do have questions, reach out to us at Stuart Green Law. We'd love to help you.